Hey, my trendies, trendsetters, and my trendy tribe. Mic check, 1 2 1 2. Let me know if you can hear me. I'm gonna have to set up a few polls today too, because I got some questions for y'all on what you're interested in. Let me see. Did y'all say y'all could hear me? You probably can. I see my circle, so that's a good sign. It's been a while since I last. Okay, I see y'all. Okay, I'm gonna do my greetings. We have announcements, and then we're gonna get into some topics, and I have questions for y'all. Okay, so hey, Veronica Monroe. Hey, Shirley Macklin. Number 4, thank you. Hey, Leslie Barber. Hey, Glow. How you doing? Hey, American Born. Number 8 on the likes. My big sis Peaches and Cream is in the house, part of the Mod Squad. Oh, I see his YouTube glitching. I got number 8 again. My sweet sis 41 Fifth says she was number 10, part of the Mod Squad, and she is an awesome content creator. Let me see here. Let me see. Shan, you could not have been number 112. Hey Hill 75, Paper Chase 22. Going down. Miss Lady 1, number 14. Thank you. Hey Teresa Wright, Pat Dyer, Kim Green. Hey Kim. Hey Auntie Natty. You changed your name on the thing. I love it. Number 15. Thank you. Kim said, let me do these last inspections so I can be ready. Let me see. Hey, Daphne Brown, Mama V, 21 Tay, April with the 2 L's is in the house. Hi. Hey, LaQuanda Govon, DG, what's up? Number 24. Okay, in the bushes, got you. Hey, Sound Checker Net at number 22. Okay. Let me see here. So, hey, y'all. Feels like it's been a while. Y'all, I'm tired. I'm so tired. I think it's because I picked up being active on more days, and I be tired. Like, I did play pickleball yesterday. It was fun. The heat zapped me. It was fun, but I'm trying to stay in like a caloric deficit. You know, doing the whole. Well, I ain't been doing that well last few days. I've been snacking a little bit, but high protein, a little bit lower calories, and all this stuff, and blah, blah, blah. I think that's what's contributing to me being tired. So I'm really, really picking and choosing where I can direct my energy and everything. Announcements are this Sunday. We got lots of, okay. Saturday, we have Saturday Night Giggles, first of all. So please come to Saturday Night Giggles. It'll be on Chef Don Don's channel. We'll keep you updated on the time because it could be 10 p.m. Eastern Standard Time, or it could be 9 p.m. Eastern Standard Time. We'll keep you updated on the time, but we have a special guest coming. I ain't gonna say too much until Don Don announces it or makes a flyer or something, but don't miss it. Be there with us, with me, Jay Taylor, and Chef Don Don. It will be fun. We all definitely want to talk about just a little bit more about Stormy and Kyle. So that will be one of the topics we talk about for sure. After that, we be ad-libbing. Can't promise nothing, but that's one I know we want to talk about. So please don't miss that. Then Sunday is the Dragon Party, the House of the Dragon Party. 41 Fit and I will be reviewing episode 6 and 7, I believe. And we will probably be starting an hour earlier than our normal time. So we'll be starting at possibly 6 p.m. Eastern Standard Time. We'll keep you posted, but that's I think the last time we're gonna do. So please come watch our review, and if you got your even if you didn't get dressed up, you can still come chill with us on screen as we go through our episode recap and everything. We would love your company. Let's see, Don Don's brunch and Mimosas with Melody is coming up next weekend. It's so close. Next weekend. I can't wait. I'm excited for y'all that get to go to Mimosas with Melody. I can't help but to experience some FOMO, but take pictures. I just want to see it all. And I will be at Don Don's brunch August 11th in Dallas. I believe tickets are still on sale, but he might be about to cut that sales channel off soon so he can have a true head count and everything. But it's denim and white is the theme, and I got my denim and white ready to go. Excited about that. Okay, so let me get my screen ready so we can go into our first thing. We're gonna do Deborah and Keairna first. And I did link in my description box the other times I talked about Deborah and Keairna. Real quick recap, the fight that happened at that restaurant where Giselle and Ashley had that fashion show. Deborah, for me, did seem like the instigator. And honestly, I feel like she bragged about being the instigator and everything at one point. But there's TMZ footage. Keairna sued Deborah. Deborah went back and countersued Keairna. So now they are plaintiff defendant and counter plaintiff counter defendant. We're going to go through and Keairna has answered the counter lawsuit against her that was filed by Deborah. So we're going to look at her answers and their witness list that they each filed. And something stuck out to me on the difference of the witness list that they filed. So, hey, Pink Diva. Pink Diva is a content creator. She is the dearest sis of Chit Chat with QT. But hey, Pink Diva. Okay, let me see here. So, let me bring this up. And if I didn't finish my sentence, I was saying I linked all the related videos in the description box when it came to Deborah and Keairna. That's what I was getting to if I didn't actually finish saying that. Let's see. There we go. Okay. So I have this pulled up because when someone answers a complaint, they have denied, acknowledged, and all these other things. So I had to go back and look at the corresponding numbers to try to keep it straight for myself. So, okay. So Keairna, it says plaintiff / counter defendant Keairna, by and through its undersigned counsel and pursuant to the rules and orders of this honorable court, hereby files this answer to defendant / counter plaintiff Deborah Williams' countersuit and respectfully states as follows. First defense, the countersuit fails to state a claim upon which relief may be granted to defendant / counter plaintiff. Second defense, in response to the enumerated paragraphs of the countersuit, plaintiff states as follows. Plaintiff denies the allegations set forth in the introduction paragraph. In the introduction paragraph, this y'all, let me read the audacity of Deborah. You have to understand. This is what Deborah said about Keairna. Hey, my big sis, Chit Chat. Obviously, Chit Chat is a content creator as well. That's my big sis right there. I love me some chit chat. Okay, so Deborah's introduction read, "It is obvious that counter-defendant Miss Keairna Stewart craves fame. She craves attention, so much so that she is willing to do just about anything to have her name broadcast on television and across social media. This includes instigating a fight, having that fight recorded, then sending the video of the fight to TMZ for it to be viewed on TV all over the world. In the reality drama she has brought before the court, Miss Stewart is not the victim. In fact, she's the villain. In the true story, Miss Stewart is not the protagonist. She's the antagonist. The facts will show that Miss Stewart, with her insatiable desire to be known, orchestrated all the events outlined in her own complaint and in this counter complaint. And in the end, the court will see, indeed, the country will see, that Miss Williams is the innocent party who has been severely damaged by Miss Stewart." So that's Deborah's counterclaim introduction. So for the parties, basically parties involved, Keairna says admitted. Paragraph 3 she says the allegations of paragraph 3 set forth a legal contention as to subject matter jurisdiction to which no averment is required. Okay. Then under the facts section, she admits to paragraph 4, which is that Real Housewives of Potomac is a reality TV series that premiered January 17, 2016 on Bravo, blah, blah, blah. Then it says, I'm going down. Okay, for paragraph 6 and 7, they say the allegations set forth in this paragraph of the countersuit do not relate to the plaintiff. No averment is therefore required. To the extent any wrongdoing is alleged as to plaintiff in this paragraph, it is denied. And paragraph 6 and 7 were that Candiace, Dillard, Bassett. It was about Candiace and Ashley's background. That was paragraph 6 and 7. Paragraph 8, plaintiff lacks knowledge or information sufficient to form a belief about the truth of the allegations in this paragraph, and that was for paragraph 8, 9, and 10, and that's probably more background. So Deborah's background, she's like, Keairna's attorney saying I can't state, whether that's true or not. That's her relationship with Ashley. That's her own background. And then paragraph 11, the allegations do not relate to the plaintiff. Number 12 is about the same. 13, I think it's because it's more background, about the same. 14 is the same. I'm getting down to where she starts denying or admitting. 16, okay, she said plaintiff lacks knowledge. Okay, 17, paragraph 17, Keairna denies. So we're going to go to paragraph 17. The first episode of Miss Williams' second season on the show began where the prior season left off, with attacks on Miss Williams. And that's Keairna and her attorney deny that. Then 18, plaintiff lacks information as to the number of episodes on which defendant appeared. Fair. 19 and 20, Keairna admits to. So 19 and 20, the episode airing in July 2023 centered on cast members Ashley Darby and Giselle Bryant, who were celebrating the launch of their clothing line. And the event was held at the Mayflower, D.C., a bar/club located on the address. All of the cast members were present at this event hosted by Miss Darby and Miss Bryant. Each member was allowed to bring friends as their guests. So that's agreed. 21, 22, plaintiff lacks knowledge or information sufficient to form a belief. And I won't read the whole thing. So Deborah's claiming that Candiace verbally attacked her viciously. And then that because Candiace could not get a rise out of Deborah, that Candiace approached Deborah, and Keairna said there's nothing, she does not have knowledge of that. Obviously, just going back to just say that for Deborah, I really just lean on the side of I don't believe anything Deborah says personally. That's me. 24 and 25, Keairna denies. And that's the one that no sooner had Miss Bassett thrown the bottle of champagne than Miss Stewart shouted out threats to Miss Williams. So Keairna's like, I did not shout out threats to her. And 25, shortly after verbally threatening Miss Williams, Miss Stewart, which is Keairna, jumped up to Miss Williams and punched her square in the face. Keairna denies that as well. 26, plaintiff denies the characterization of plaintiff's response to being struck in the face by defendant's heavy glass cup as an attack on Miss Williams. Plaintiff admits that she was not a regular cast member on the night of the occurrence. Plaintiff admits that she had never met defendant before the night of the occurrence. Plaintiff admits that she had not exchanged words with defendant before defendant initiated the occurrence by throwing a drink in a heavy glass cup. Plaintiff denies the remaining allegations. 27, she denies, paragraph 27, which is upon investigation and belief, Ms. Stewart was there for the sole purpose of fighting Ms. Williams. Yeah, Keairna, to me, did not come to fight Deborah. And then 28, she admits, before the fight, the producers of the show had stopped recording. This means this entire fight was not captured on camera by the Bravo TV crew. So that's what she admits to. 29, plaintiff admits that cell phone footage appears to capture the scene immediately before defendant threw a drink on plaintiff and Miss Bassett. So Deborah was saying Keairna is the one that planned to have everything recorded. In other paragraphs, that's what she alleged. But she does acknowledge that right before the fight happened, someone was recording their interaction. 30, she denies. She denies that it was her, Keairna, that knew that she was going to go attack Deborah. So she's like, no. Let's see. She lacks knowledge for 31. 32, she admits. Okay, that in her complaint, in Keairna's complaint, she did allege that Deborah threw an empty heavy glass cup at Keairna. Let me see. 33, 34, and 35, she denies. And basically, she's denying that this is horrible. Deborah said the reason that Keairna got the laceration on her forehead is because she had on a wig, and the wig, when it got ripped off, gave her a laceration on her forehead. I'm going to keep going. We went over that. 36, she says she lacks knowledge of any therapy or mental health care treatment that the defendant received or is receiving, and she denies the remainder of the paragraph. All right. Paragraph 38, she denies, which is Miss Stewart is liable to Miss Williams in assault because she intentionally and unlawfully threatened to do physical harm to Miss Williams. I know American Born. That wig pull talking about laceration on the forehead is too much for me. Let me see here. And then 40, 41, 42, and 43, she denies. So 40 through 43. She denies that she yelled out threats to Deborah. She denies, again, threatening to cause bodily harm. She denies that Deborah suffered emotional harm as a result of Keairna's actions. She denies that she's liable to Deborah in battery because of intentionally punching Deborah in the face without justification. So she denies all of those. 44, the allegations of this paragraph set forth a legal contention as to the elements for a cause of action for battery to which no averment is required. 45, plaintiff admits that during the physical fight, which began after defendant threw a drink on plaintiff and Miss Bassett, and after defendant threw a heavy glass cup at plaintiff's head, plaintiff may have punched defendant in the face. 46, she denies. So 46 is Keairna was acting in self-defense when she punched Deborah in the face. So I wonder if she denied that because she's saying I'm not admitting I for sure punched her in the face. Maybe that's why she's denying it. 40. Oh, no, she's saying, okay, Deborah in paragraph 46 is saying that Keairna was not acting in self-defense. And Keairna is saying she denies that because I'm sure she was acting in self-defense. Then 47, she admits to that the punching was recorded and broadcast through social media, allowing viewers all over the world to witness the event. I think she denies 48. Which is Miss Stewart's intentional actions have caused severe emotional and physical damage to Miss Williams. Okay. 50, paragraph 50, she denies. Miss Stewart is liable in the intentional infliction of emotional distress for her unprovoked, intentional, and extremely reckless behavior. And 52, it says plaintiff, which is Keairna. I'm trying to keep them straight because I know it's a lot of she's and hers and all that. So I'm trying to keep it straight that Stewart is Keairna, Williams is Deborah, and the plaintiff right now is Keairna. So it says plaintiff denies that her conduct was extreme and outrageous and or intentional and reckless. Plaintiff admits that the setting where the event occurred was formal and many people were present. Plaintiff admits that during the physical altercation, which defendant initiated by physically attacking plaintiff and Ms. Bassett, plaintiff may have struck defendant in her face with her fist. Plaintiff denies the remaining allegations of this paragraph. In 53, she also denies, Keairna denies that Deborah suffered and is suffering emotional distress. See, 55, she denies. 55, 57, 58, 59, she denies. So she denies she's liable. 57, she's denying that she made several statements about Deborah that were patently false. 58, she denies that she made sure that a statement was published around the world through TMZ. 59, she denies that any statement was made intentionally and recklessly. And then was 60. 60, it says, Keairna lacks knowledge or information as to whether Deborah's reputation and career have suffered. Baby, yeah, I'm with her. What reputation? She denies all allegations on the third defense, fourth defense, and let's see. Plaintiff denies any of the acts or omissions alleged in the countersuit were approximate cause of defendant's alleged damages. Defendant is not entitled to any relief requested because defendant initiated the physical altercation. Defendant, being Deborah, assumed the risk of the injuries alleged. Defendant Deborah has waived and or released the claims alleged herein. Deborah's claims are barred by estoppel. The alleged statements attributed to Keairna were true and were not false. Defendant's claims are barred in whole or in part by defendant Deborah's failure to mitigate damages. And wait, no, not and we're not done. Okay. Defendant Deborah's countersuit is subject to dismissal pursuant to the District of Columbia's anti-strategic lawsuits against public participation. So the anti-SLAPP, basically, statute. Plaintiff reserves the right to supplement or amend this answer as new or additional information may become available via investigation or discovery. Okay, so now let's get to the witness list. We're going to look at Deborah's witness list first. So this is Deborah's witness list. This is where I can see the differences. Okay. And hey, who came in here? Hey, Don, that's who came in here. Hey, Don, y'all go support my friend, Don, who is a content creator. Okay. Don, I was telling him we had a special guest, but I didn't say who because I didn't know how much you still needed or anything. But I was telling him we had a special guest for Saturday Night Giggles tomorrow night. Okay. So the witness list for Deborah's side is Keairna, Deborah herself. I'm sorry if I say these names wrong. Sharita Cookie Whiting, Winter Harris. Oh, Winter. They done wrote Winter in. Candiace Dillard Bassett, Ashley Darby, Jacqueline Blake. Jacqueline, I think that's Mia's friend. Mia Thornton, Wendy Osefo, Karen Huger, Sydney Hare, Jules McGuire, Nneka, Corey Williams, Joseph Williams, Brandon McLaughlin, Carmen Felder, Cornelius Bryant, Camille Hazel, Eric Fuller. Is Eric's a producer, right? Eric Fuller? I think that's a producer. Courtney Snipes, Jasmine Chanel, and Sylvia. I'm just going to say Sylvia, owner of the nightclub. So that's her witness list. Now, y'all see her witness list, and I just want you to see if you notice the difference I noticed as soon as I looked at Keairna's witness list. So I won't say what I noticed until y'all make your own observation first. So that was Deborah's witness list. Here's Keairna's. Okay, so Keairna is calling herself as a witness, Deborah as a witness, Candiace as a witness, Officer Anthony Sousa of the Metropolitan Police Department, Officer David Cassetta, Metropolitan Police Department, Officer William Parker, Metropolitan Police Department, Anthony Hector, detective of the Metropolitan Police Department. I guess so, Donna, because Deborah, excuse me, put Winter on her witness list. Excuse me, sorry, y'all. Any individual who appears on the video of the occurrence identified in the complaint. Any individual who was physically present at the address during the occurrence and the events preceding the occurrence. Nicole Williams, MD. Rami, MD. Molly, PA. David Vanson, MD. At Howard University Hospital. Jason from Patient First. Gregory Diggs, MD. The custodian of records or other competent representative of TMZ with knowledge of TMZ came to possess, or with knowledge of, I think, how TMZ came to possess the video of the occurrence identified in the complaint. The unknown individual who took the video identified in the complaint. The custodians of records for each of plaintiff/counter defendants' medical providers, any party to this action, any and all witnesses identified by any party to this action, any person listed or named on any document produced for inspection and copying by any party to this action during discovery or any person identified during discovery. Ms. Stewart reserves the right to supplement this list of fact witnesses upon the close of discovery and at any time prior to the entry of the pretrial order in this matter. This list of fact witnesses does not include persons or entities that may be called as rebuttal or impeachment witnesses. This list of fact witnesses may not include persons who may be called as expert witnesses. Okay. All right. So first of all, let me know, did you notice the difference between those two witness lists, and what difference did you notice? Because we have gone through it, and then I'll tell you what I noticed after y'all tell me what you noticed. Because I just want to see before I say it if anybody else. Winter, they trying to drag you in mess. Donna said kind of makes sense now. Kim said other reality stars normally be at other franchises launching products party. Okay, I'll wait for one more comment to come through, and I'm just going to name the differences, the significant difference that I saw, and then some other things too. I'm just double checking before I go on. Okay, I don't see it, so I'm going to say it. First of all, Deborah's list, does she have an attorney? Okay, I had to double check she had an attorney, because for me, every time I've seen someone do a list of witnesses and other things, they always say, I ain't gonna hold you. Even on the Scolt Zen Gardens case, I think even the Scolt side attorney said they reserve the right to call other witnesses, or, there was something that I'm always seeing. So for her attorney not to have that, I know it could probably be amended, but that to me is just one of those basic no-brainers. I thought that they usually put like, we reserve the right. This list is not all. And then the fact that they didn't reserve the right to also call witnesses that the other side lists. The other difference, Auntie Nettie, I didn't even think about that one. Now, here's the thing. Giselle had left before it occurred. That's what I always heard. Giselle was not there for that fight. That might be why they left Giselle off the list, because she wasn't there, is what I heard. And thank you. This is the one, Auntie Natty. Keairna has police and doctors in her list. That was the other thing I noticed. Deborah from the get-go took this matter seriously, in my opinion. Not Deborah. Keairna from the get-go took this matter seriously, and Deborah is just now trying to counteract what was already taken seriously from Keairna's side. So Keairna is calling 1, 2, 3, 4 people from the Metro Police Department. Then she has medical people that she listed. And Deborah didn't even list, although she said she suffered this mental anguish. She didn't even list, unless she didn't put their title beside it. I don't see her listing a therapist or anybody to talk about that mental anguish side of it. So that was something I noticed. So yeah, Keiarna'S is way more professional, is the biggest thing that I noticed. This is what I was expecting to see. Reserves the right to supplement this list of fact witnesses. I just thought all attorneys would put something like that. I would, and she should have. But you see what I'm saying? That's why I'm saying I think Deborah is full of SHIT. I think she's full of it, because I just think she's filing this to file it, when Keairna'S like, no, for real, you assaulted me, and I'm not just going to not talk about it and not take it seriously. So yeah. Let me see what else. Oh, okay, Donna's talking to somebody else in there. Okay, but yeah, so that was what the significant differences that I noticed. There's probably more, but as soon as I saw it, I was like, Oh yeah, Deborah's playing around, and Keairna is serious. Yeah, Candiace is on both lists. Yep. Okay. All right. Now we're about to move on to Nesto and what he filed, and also what Dennis Byron I'm gonna hold on at the bottom. I don't know if it's Dennis for sure, but I know that Dennis Byron runs Hip Hop Enquirer. So for me, it's synonymous. If I see Hip Hop Enquirer, I'm thinking Dennis Byron. So that's why I'm saying that. So I might be making an assumption. Hold on, y'all. Clear my throat. Okay. Yep, on to Nasty Nesto. And yes, Deborah is full of it, Don Don. She is full of it. All right. So, first of all, because Nesto's side, of course, wanted a gag order in place. And so Hip Hop Enquirer filed in opposition to defendant's motion for gag order. And it says, movement, Hip Hop Enquirer magazine, a non-party to the case at bar, hereby opposes defendant Earnest Williams's motion for a gag order on the media to cover his upcoming trial. Hip Hop Enquirer asserts that such a gag order would contravene the principles of the First Amendment and undermine the public's right to access information about matters of significant public interest. Furthermore, defendant's motion fails to meet the requisite legal standards for the imposition of a gag order. Auntie Natty said Nasty Nesto about to get baptized. Okay. The argument, the First Amendment right to freedom of the press. The First Amendment to the United States Constitution guarantees the freedom of the press. The Supreme Court has consistently recognized that the press plays a vital role in our democracy by serving as a watchdog over the government and ensuring transparency and accountability. In Nebraska Press Association v. Stewart, the court held that prior restraints on the press are presumptively unconstitutional and can only be justified in exceptional circumstances where there is a clear and present danger to the fair administration of justice. The standard for imposing a gag order. In determining whether to impose a gag order, courts must balance the defendant's right to a fair trial with the public's right to access information. The burden is on the party seeking the gag order to demonstrate that there is a substantial probability that pre-trial publicity will prejudice the defendant's right to a fair trial. This burden is a heavy one, requiring clear and convincing evidence of the need for such an extraordinary remedy. Application to the present case. In the instant case, defendant has failed to meet his burden of showing that a gag order is necessary to protect his right to a fair trial. While defendant may have concerns about the potential impact of media coverage on the jury pool, mere speculation or conjecture is insufficient to warrant the imposition of a gag order. Defendant has not presented any concrete evidence of actual or imminent prejudice that would justify such a drastic measure. Moreover, the charges against defendant involve allegations of fraud, identity theft, bigamy, corruption, and racketeering, which are matters of significant public interest. The public has a right to be informed about the proceedings in this case and to participate in the debate over issues of corruption and accountability in government. Conclusion, for the foregoing reasons, Hip Hop Enquirer respectfully requests that this honorable court deny defendant's motion for a gag order. Such an order would constitute an unconstitutional prior restraint on the freedom of the press and would undermine the principles of open and transparent justice. So that was the first thing I had for y'all about Nasty Nesto's case, because, he definitely, those phone calls, I don't know if y'all know the TikTok song is like, these BBLs be killing y'all. That's all I could think. That's what I have in my head, but it's these phone calls be killing Nesto. It's the phone calls. It's not Dennis Byron or anybody else been in that courtroom recording the proceedings. The phone calls is tearing him every which way but loose. That's all I keep thinking about. Okay, let me see here. So this is Nesto's attorney filing for him. It's a general, come on, Southern tongue, Demurrer to count one, Rico. On August 23rd, 2024, the state of Georgia filed a 35-page indictment consisting of 39 counts against 2 defendants, including Earnest Williams. Earnest Williams is charged with all 39 counts, including 1 count violation of the Georgia RICO Act. In this pleading, Earnest Williams challenges count 1 of this indictment, which purports to allege a RICO conspiracy. Count 1 fails to allege an offense and is subject to general and special demurrers because it A, fails to properly allege the elements of the offense of a RICO conspiracy, fails to recite facts that identify the basis for the allegations, fails to adequately allege the dates of the offense and date that any co-conspirator is alleged to have joined the conspiracy, fails to allege the identity of co-conspirators, fails to comply with the statutory requirements, fails to properly allege either the elements or the factual basis for the alleged racketeering acts, fails to allege what conduct is alleged to be an overt act of the conspiracy as opposed to or in addition to being a racketeering act, fails to adequately allege the relationship between the listed overt acts / racketeering acts and the alleged but ill-defined enterprise. Legal basis for special and general demurrers. The basis for a general, I feel like I'm saying this word wrong, and I'm getting self-conscious every time I have to say it. The basis for a general demurrer is the failure of the indictment to allege an offense. If theoretically a defendant could agree that every fact alleged in the indictment is true and still be innocent of the crime charged, a general demurrer would succeed. Often a general demurrer is predicated on the failure of an indictment to allege the essential elements of an offense, but the failure to adequately allege the facts that demonstrate the satisfaction of an element also supports a general demurrer. The indictment must set forth the elements of the offense, as well as the facts that show that the defendant is culpable as a party to the crime, as a conspirator, or as a principal for the commission of each element. If an indictment alleges an offense, but the allegation violates the Constitution as applied, or if the criminal offense is facially unconstitutional, this too will support a successful general demurrer. And I do have the state's response to this also. I don't understand how Nesto doesn't understand how they definitely identified him as the main party for the offenses that they listed. They definitely identified him because he's trying to act like somebody else committed these crimes, or I don't know. Like, what are you talking about? A special demurrer addresses the failure of the indictment to allege the facts with sufficient particularity. For example, the date of the offense, and in this case, the date that any individual co-conspirator allegedly joined the conspiracy is not revealed, or a date range is too broad. The identity of the victim of a crime is not identified. The location of an offense is not alleged. In these situations, a special demurrer acknowledges that a crime has been alleged, but the indictment is not perfect in form and substance, thus depriving the defendant of the ability to prepare their defense intelligently. The indictment is therefore subject to a pretrial special demurrer. State versus Heath. If the court grants a general or special demurrer, the result is the dismissal of the targeted count of the indictment. The prosecutor may not hoover up inappropriate surplusage or add a date or allege an inadvertently omitted element. The grand jury return the indictment, and if it needs to be corrected, the grand jury must do so. The following cases illustrate the appellate court's intolerance in the past 25 years of defective indictments. Okay, hold on. Before I read these cases, what I want to see, before I say what I have to say, because I might be saying something and it's here, and I'm like, oh, well, never mind. That just took out what I was going to say. Hold on. Okay. Okay, yeah, let's skip down from the case examples to the inadequacies of the indictment that they're claiming. Okay, Shan said Nesto is blaming Erica for setting him up. Boy, he gotta stop. He gotta stop. 41 Fifth said he's choosing to be obtuse, in my opinion, right? Kim, yes, these phone calls be killing y'all. It's taking him out. Dion told him to stop running his mouth. He did, Aunt Natty. He sure did. He sure did. And we're making good time, so we might have to, depending on the state's response, we might have to listen to Nesto and Dion call because Dion was shut up. Nesto's blaming Erica. Oh, yes. Thank you for being here, LV Sweet Mom. I appreciate you. Okay. The inadequacies of the indictment that Nesto's attorney and he are claiming. So it says the foregoing precedents demonstrate that an indictment must do more than simply cite a statute. It must do more than just list the elements of the offense. It must allege the outlawed conduct in an unambiguous manner that is not exploiting an inherently vague statute, Hall v. State. It must allege facts, not just generic elements, State v. the levy, and must provide the necessary information for each offense when the indictment alleges a compound offense such as RICO. In count 1 of the indictment, the state charges Mr. Williams with the offense of violation of the Georgia RICO Act. For the said accused, individually and a person concerned in the commission of a crime in Fulton County, Georgia, on or between December 1st, 2009 and June 30th, 2022, acquired and maintained directly and indirectly an interest in and control of real property and personal property, including but not limited to United States currency, personal vehicles, motorcycles, coach buses, trailers, automotive parts, and a residence through a pattern of racketeering activity as described below and incorporated by reference as if fully set forth herein. The state goes on to describe the primary purpose of the alleged RICO scheme as depriving numerous victims of their property. The state alleges Mr. Williams did so by falsely promising to help victims engage in new business ventures, to promote their existing business ventures, or to help them build their brand or image. The state further alleges Mr. Williams recruited multiple co-conspirators, including Erica King, during the course of the scheme. Under the Acts of Racketeering Activity section, the state alleges Mr. Williams engaged in 57 predicate acts that had the same and similar intents, results, accomplices, victims, and methods of commission, and otherwise were interrelated by distinguishing characteristics and were not isolated incidents. The state doesn't put the defense on notice as to what to defend against. Okay. Failure to properly allege racketeering acts. A RICO conspiracy charge requires proof that a defendant conspired to participate in the affairs of an enterprise through the commission of at least 2 predicate racketeering acts. The predicate acts must be set forth with the same degree of specificity as if they were standalone crimes. In the indictment, the state posits the primary purpose of the alleged RICO scheme is to deprive numerous victims of their property. It goes on to say Mr. Williams achieved this primary purpose by falsely promising to help victims engage in new business ventures, to promote their existing business ventures, or to help them build their brand or image. The indictment lists out of 57 predicate acts consisting of various types of theft, false swearing, filing false documents, and fraud. However, none of the listed predicate acts set forth any degree of specificity as to how they are alleged to support or further purpose of said conspiracy. An essential element of the offense of participating in the affairs of the enterprise through a pattern of racketeering activity is a connection or nexus between the enterprise and the racketeering activity. A pattern of racketeering activity within meaning of state, Racketeer Influence and Corruption Organization statute means engaging in at least 2 incidents of racketeering activity. Because the state has failed to show any type of connection between the enterprise and the predicate acts, count 1 does not allege an offense under the RICO Act. The enterprise is inadequately defined. The enterprise element of the offense is not sufficiently described, and for that reason, count 1 does not allege an offense. The indictment alleges Mr. Williams was a participant in and responsible for each of the 57 acts, but there is no suggestion that any other unindicted co-conspirator agreed or conspired to participate in said acts. Mr. Williams is left to guess which unindicted co-conspirator is alleged to have conspired to commit any racketeering act in which he or she was not named. Moreover, the indictment fails to specify when, where, or how individual unindicted co-conspirators joined the conspiracy, as well as their individual participation in said conspiracy. Okay, so they want the state to name his co-conspirator, specifically actually name his co-conspirator, because there's no conspiracy, I guess, without a co-conspirator in RICO. I think that's what they're trying to stand on. Like, what? So who are those names of the people? or person, which I know for us, I'm thinking Erica, but I feel like he could have had other people too that they might name. I don't know, but that's what they're asking for. Like, how do you say conspiracy if there was nobody else to conspire with? That they didn't name. That's what he's saying. And we'll look at the state's response. It says, for the above outlined reasons, Earnest Williams cannot adequately prepare for a defense of his charges. As such, he is being denied his federal and state constitutional due process rights. Wherefore, based on the foregoing, Earnest Williams prays that this court grant his demurrer to count 1 alleged in the indictment, quash or dismiss the indictment or each count as specified, and grant Earnest Williams any other relief as this court deems just. And that was done July 22nd, 2024. Let's see. Hey, Francois. Thank you. Okay, you at work. I understand. Okay, so let's look at the state's response to Earnest and his attorney. So it says, comes now the state of Georgia by and through Fulton County District Attorney Fannie Willis and responds in opposition to the defendant's general demurrer to count 1, Rico. Count 1 of the 35-page indictment charges that the defendant violated the Georgia RICO Act by stealing United States currency, personal vehicles, motorcycles, coach buses, trailers, automotive parts, and other property from numerous victims in numerous states over a period spanning more than a decade, ending only when the defendant was arrested and incarcerated on July 7th, 2022, just 7 days after the last alleged act of racketeering activity committed by him. The indictment details a total of 57 acts of racketeering activity committed by him. The indictment details a total of 57 acts of racketeering activity committed by the defendant and names at least, they name at least, 29 different individuals, businesses, and governmental entities that were victims of the defendant's 12-year-long criminal scheme. Each of the 57 acts of racketeering activity enumerated in count 1, which itself spans 16 pages, alleges all the essential elements making up each of the defendant's underlying crimes that constitute racketeering activity. Those underlying crimes include theft by taking, theft by conversion, theft by deception, theft of services, theft by bringing stolen property into the state, acts involving theft, false swearing, filing false documents, false statements and writings, identity fraud, and deposit account fraud. Still perplexingly, the defendant complains that count 1 is insufficiently pled such that he cannot adequately prepare an intelligent defense. The defendant seeks dismissal of count 1 on multiple unsupported grounds, many of which are inapplicable because the defendant is not charged with a RICO conspiracy violation. Aha, okay. And that was his whole thing. He was saying the state would not name co-conspirators, but the state is saying he's not charged with a RICO conspiracy violation. Okay. Shan said unindicted co-conspirator can't be and isn't Erica. She was indicted. Auntie Natty said, Wooten said, I play chess, y'all. Y'all playing checkers, right? Not no.gov. Theft of everything and they mama, right. So there you go. They're saying we didn't charge you with conspiracy, though. That wasn't the violation that we chose. So there's the answer to the whole thing that they really kind of leaned on was the conspiracy part of it, I guess. So it says the defendant incorrectly argues that pleading requirements for RICO conspiracy violations and RICO enterprise violations apply to all Georgia RICO Act violations. As a threshold matter, the defendant fundamentally misunderstands the various methods by which a person may violate the Georgia RICO Act. And his motion incorrectly argues that pleading requirements for RICO conspiracy violations and RICO enterprise violations apply to all alleged RICO violations. Oh, man. So your lawyer, I wonder, did the lawyer try to explain this to him or did he just say, I'll file? If that's what you want me to file, I'll file it. Because also in saying that the defendant doesn't understand, to me, you're also saying that the attorney for the defendant that wrote the document up may not understand. Or, you know what I'm saying? Like inadvertently. I'm not saying that's what they said, but I wonder if the attorney tried to tell him that does not matter. That's not how RICO charges work. I always wonder about those conversations before the attorneys submit their documents. And you see how Nesto be talking on the phone with his people about the attorneys and stuff. So I really wonder. And then, Sonia's the to-be lawyer. So she probably really sold that to him to say, you need to get your lawyer to argue this. Oh my gosh, I can hear it. Okay. Let's see here. They clearly do not. Significantly, in this case, the defendant is not charged with a RICO conspiracy violation. He is not charged with acquiring or maintaining an interest in or control of a RICO enterprise. He is not charged with being employed by or associated with a RICO enterprise. And he is not charged with participating in a RICO enterprise through a pattern of racketeering activity. Accordingly, all of the defendant's arguments related to RICO conspiracy violations or RICO enterprise violations are meritless and should be disregarded. Okay. I hear you, Shan. I always wonder what's that line between you try to advise your client and you still go ahead and file certain things. Because I thought there was a line. I guess this one is not towing that line. Because I thought, like, you know what I mean? Like, I feel like there is some kind of line where an attorney's like, I'm not filing that. I can't file that in good faith. So I just wonder where that line is. Hill 75 says Sonya is his lawyer. He only listens to Sonya. Yes. Okay, let's see here. The Georgia RICO Act prohibits 3 general categories of criminal conduct. First, OCGA prohibits any person from acquiring or maintaining directly or indirectly any interest in or control of any enterprise, any real property, or any personal property of any nature through a pattern of racketeering activity or proceeds derived therefrom. Second, OCGA prohibits any person employed by or associated with an enterprise from participating in that enterprise directly or indirectly through a pattern of racketeering activity. Finally, OCGA prohibits any person from conspiring or endeavoring to violate any of the provisions of OCGA. The indictment in this case charges that the defendant violated OCGA 16-14-4A in that he, individually and as a person concerned in the commission of a crime in Fulton County, Georgia, on and between December 1st, 2009 and June 30th, 2022, acquired and maintained directly and indirectly an interest in and control of real property and personal property, including but not limited to United States currency, personal vehicles, motorcycles, coach buses, trailers, automotive parts, and a residence through a pattern of racketeering activity. Let's see. Oh, I'm Natty. I can't with you. He'll say 5 say get comfortable, Nesto. You're not going anywhere. Indictment at 6. The defendant is charged with acquiring and maintaining an interest in and control of real property and personal property, not an enterprise. An indictment charging a RICO violation under OCGA 16-14-4A may charge that a defendant acquired or maintained an interest in or control of an enterprise, but it is not required to. That is simply one way of violating OCGA. But no enterprise is alleged in this case. An indictment framed only as a violation of OCGA 16-14-4A does not require that there be proof of an enterprise, but only that the accused, through a pattern of racketeering activity or proceeds derived therefrom, acquired or maintained directly or indirectly any real property or personal property of any nature, including money. Dover v. State. When charged in this manner, there is no requirement that an enterprise or defendant's association with it be proven at trial or, by extension, alleged in the indictment. An indictment charging a RICO violation certainly must allege that a defendant was either employed by or associated with an enterprise and then conducted or participated in that enterprise through a pattern of racketeering activity, but the defendant here is not charged with violating OCGA 16-14-B, and those pleadings requirements do not apply. Likewise, an indictment charging a RICO conspiracy violation under OCGA 16-14-4C certainly must allege that a person conspired with one or more persons to violate OCGA 16-14-4A and B, and that one or more of such persons committed an overt act to affect the object of the conspiracy. But once again, the defendant here is not charged with violating OCGA 16-14-4C, and those pleading requirements do not apply. Accordingly, As detailed more specifically below, the defendant's arguments concerning pleading requirements for RICO enterprise cases and RICO conspiracy cases categorically do not apply here. Woo! How is he paying for this? I know he has one public defender, and then there's one attorney that the judge said that the attorney can't withdraw himself. I don't know if that name that signed this document is a different name from the ones we've seen as we've been following, because I'm not a name person as it is. I don't know. So I can't tell if this is the attorney that was denied, that he couldn't like get out of representing Nesto. But the public defender was a woman. So I know this one is not the public defender that's a woman. But yeah, so Shan, if you know, please answer that. And thank you for the super chat, Dwayne. I appreciate it. Dwayne is Pierre. Thank you. Okay. So now it says count 1 is not required to allege the elements of a RICO conspiracy violation because no RICO conspiracy is charged, but it adequately alleges a RICO substantive violation sufficient to survive general demurrer. The defendant complains that count 1 fails to properly allege the elements of the offense of a RICO conspiracy. Defendant's motion at 1, as explained above, the defendant is not charged with a RICO conspiracy, but instead is charged with a RICO substantive violation. As such, no RICO conspiracy is alleged. Still, count 1 is adequately alleged to survive general demurrer. To assess the merits of a general demurrer, which challenges the sufficiency of the substance of the indictment, a court asks whether the defendant can admit each and every fact alleged in the indictment and still be innocent of any crime. If so, the general demurrer should be sustained, State v. Williams. By contrast, if the admission of the facts alleged would lead necessarily to the conclusion that the accused is guilty of a crime, the indictment is sufficient to withstand a general demurrer. Moreover, deeply embedded within Georgia case law is the concept that a charging instrument that tracks the statutory language of a criminal offense is sufficient to survive a general demurrer. The essential elements of a RICO substantive violation are as follows. It shall be unlawful for any person to acquire or maintain directly or indirectly any interest in or control of any enterprise, real property, or personal property of any nature, including money, through a pattern of racketeering activity. Count 1 charges in pertinent part that the defendant, on and between December 1st, 2009 and June 30th, 2022, 1, acquired and maintained directly and indirectly, 2, an interest in and control of real property and personal property, including but not limited to U.S. currency, personal vehicles, motorcycles, coach buses, trailers, automotive parts, and a residence. 3, through a pattern of racketeering activity. Indictment at 6. The pertinent language of count 1 tracks the statutory language of OCGA 16-4-4A. And if the defendant were to admit to the allegations, it would necessarily lead to the conclusion that he is guilty of a RICO substantive violation. Count 1 sufficiently alleges the dates of the offense charged, and it is not required to allege the date that any co-conspirator joined a conspiracy because no RICO conspiracy is charged. The defendant complains that count 1 must be dismissed because it fails to adequately allege the dates of the offense and the date that any co-conspirator is alleged to have joined the conspiracy. Defendant's motion at 1, count 1, explicitly alleges the dates of the offense as on and between December 1st, 2009 and June 30th, 2022. Indictment at 6, that date range is repeated in the manner and methods of the RICO scheme portion of the account. From at least December 1st, 2009 through June 30th, 2022, Earnest Williams engaged in a pattern of racketeering activity in Fulton County, Georgia, elsewhere in the state of Georgia, and in other states. Additionally, the acts of racketeering activity portion of count 1 specifically alleges the dates of each of the 57 enumerated acts of racketeering activity committed by the defendant. Count 1 not only adequately alleges the dates of the offense, but it does so at least 3 times. The defendant's demurrer on this ground should be overruled and denied. As to the defendant's second argument regarding the dates any co-conspirator is alleged to have joined the conspiracy, first, as set forth above, the defendant is not charged with a RICO conspiracy violation. This is simply not a RICO conspiracy case. Second, the lone act of racketeering activity involving an unindicted co-conspirator, Act 38, alleges that the defendant solicited and coerced unindicted co-conspirator Individual 1 to commit a felony. Indictment is 17. That solicitation committed by the defendant is an act involving felony theft, which constitutes racketeering activity. The relevant question then is not whether or when unindicted co-conspirator Individual 1 committed a felony, but instead when the defendant solicited unindicted co-conspirator Individual 1 to do so, which is explicitly alleged to have occurred on or about November 21st, 2021. The defendant's demurrer on this ground should be overruled and denied. Count 1 is not required to allege the identities of unindicted co-conspirators, and those identities have been provided to the defendant in discovery. The defendant complains that Count 1 must be dismissed because it fails to allege the identity of co-conspirators. While this is not a RICO conspiracy case, as explained above, and only the defendant is charged with a RICO violation, Count 1 alleges that the defendant solicited and coerced 2 individuals to commit acts of racketeering activity throughout the course of his scheme. The first, co-defendant Erica King, is listed by name at least 58 times throughout the indictment as a whole and at least 24 times in Count 1 alone. The second, unindicted co-conspirator Individual 1, is not named because they have not been charged with any crime. Not only is it not required for an indictment to name unindicted co-conspirators, and the defendant cites no authority to the contrary, persuasive federal authority from the former Fifth Circuit suggests that naming an unindicted co-conspirator is beyond the power of a grand jury and violates their due process rights when they are not charged with any crime. U.S. versus Briggs. Further, the defendant has been provided with the identity of unindicted co-conspirator Individual 1 in discovery. His demurrer on this ground should be overruled and denied. Count 1 complies with the pleading requirements set forth in OCGA 17-7-54A because it states the offense in the terms and language of the code. The defendant complains that Count 1 must be dismissed because it fails to comply with the statutory requirements of OCGA 17-7-54. He then quotes that code section which provides that every indictment of the grand jury which states the offense in the terms and language of this code, or so plainly that the nature of the offense charged may be easily understood by the jury, shall be deemed sufficiently technical and correct. As set forth above, Count 1 precisely tracks the statutory language and is therefore not subject to general demurrer. The Supreme Court of Georgia has explained as much when specifically analyzing arguments made in other cases. An indictment couched in the language of the statute alleged to have been violated is not subject to a general demurrer. Count 1 tracks the statutory language for the crime it alleges, so it is not subject to a general demurrer. The defendant's statutory argument is meritless, and his demurrer on this ground should be overruled and denied. While Count 1 is not required to allege acts of racketeering activity with any level of specificity, it nevertheless does so, alleging all of the elements of each underlying criminal offense and identifying the factual basis for each with specificity. The defendant complains that Count 1 must be dismissed because it fails to allege either the elements or the factual basis for the alleged racketeering acts. Without citing any authority, the defendant concludes that in a RICO indictment, predicate acts must be set forth with the same degree of specificity as if they were standalone crimes. The defendant's argument fails for multiple reasons. First, the statutory definition of racketeering activity demonstrates the gravest flaw in the defendant's argument. When they do the extra description words, I get like, oh, okay, because like, not are they just breaking down the argument. I love the gravest flaw is like for me like, oh, okay, that was a big mistake. Okay. But it says racketeering activity falls into 3 major categories. The first category includes committing, attempting to commit, or soliciting, coercing, or intimidating another to commit a list of specified Georgia crimes. The second category includes any conduct defined as racketeering activity. Any violation of 18 U.S.C. Section 1028 or any violation of 31 U.S.C. Sections 5311 through 5330. The final category is much broader and includes any act or threat involving unaliving, kidnapping, gambling, arson, robbery, theft, receipt of stolen property, bribery, extortion, obstruction of justice, dealing in narcotic or dangerous substances, or dealing in securities, chargeable under the laws of any state or territory of the U.S. or under federal law, and punishable by imprisonment for more than 1 year. By broadly prohibiting any act or threat involving any one of these categories of crimes, the General Assembly intentionally did not limit the definition of racketeering activity to completed crimes. It chose the words any act or threat involving because it meant exactly that. And a court construing a statute must presume that the General Assembly meant what it said and said what it meant. Bell v. Hargrove. Is that the quote? It sounds like a song lyric or just like a auntie saying it meant what it said and it said what it meant. Georgia courts must afford the statutory text its plain and ordinary meaning, viewing the statutory text in the context in which it appears, and reading the statutory text in its most natural and reasonable way, as an ordinary speaker of the English language would. Well, that's the problem. Reading it as an ordinary speaker of the English language would. This is Nesto. Nesto, he got the wander gene. He doesn't speak the natural language. I'm sorry, y'all. If y'all heard those phone calls, you know what I'm saying. Okay, it says, let me get back to my thing. When statutory text is clear and unambiguous, the interpretive task begins and ends with the text itself. And if there were any room for doubt, the General Assembly set out its legislative intent in the law itself. Wooten said what he said, Auntie Nettie. It is the intent of the General Assembly that this chapter apply to an interrelated pattern of criminal activity motivated by or the effect of which is pecuniary gain or economic or physical threat or injury. This chapter shall be liberally construed to effectuate the remedial purposes embodied in its operative provisions. Moreover, the Supreme Court of Georgia addressed a similar argument in Dorsey v. State. In that case, the defendant argued on appeal that acts involving unaliving, which were not themselves completed crimes, could not constitute racketeering activity. The court flatly rejected that argument, recognizing that any act that directly concerns any of the broad categories of crimes enumerated in OCGA 16-14-35B clearly falls within the definition of racketeering activity, even if such an act standing alone may not be criminal. Accordingly, because acts of racketeering activity themselves are not required to be completed crimes, it is illogical and unsupported by law to conclude, as the defendant has, that predicate acts must be set forth with the same degree of specificity as if they were standalone crimes. That is simply not the law of this state. So the other argument, so they've already broken down we didn't say we were charging you with conspiracy. Now they've also said, how did they say it? Hold on. Wooten said what he said. But they said that, hold on, let me read it again. This last part, that predicate acts must be set forth with the same degree of specificity as if they were standalone crimes. The standalone crimes part is what they also were leaning on in his motion. That was what I was trying to get to. Okay. The Supreme Court of Georgia has also rejected this argument in the context of indictments charging conspiracy crimes. In that context, the court has held, we find no authority requiring the indictment to set forth the particulars of the overt act in great detail. The same logic applies here. Finally, even assuming the defendant's argument has merit, and it does not, the indictment would still survive Demurrer. Each of the 57 enumerated acts of racketeering activity alleges all of the essential elements of the underlying crimes. And if the defendant were to admit to them, it would lead necessarily to the conclusion that he is guilty of a crime. Moreover, each act of racketeering activity, as alleged, sufficiently apprises the defendant of what he must be prepared to meet and is sufficiently alleged to protect against double jeopardy. For these reasons, the defendant's demurrer on this ground should be overruled and denied. Count 1 is not required to differentiate between overt acts in furtherance of a conspiracy and acts of racketeering activity because no RICO conspiracy is charged. The defendant complains that count 1 must be dismissed because it fails to allege what conduct is alleged to be an overt act of the conspiracy as opposed to or in addition to being a racketeering act. I just want to say this. I say within their first 1 to 3 paragraphs, they already blew that argument out the water. So at this point, it's just like, we don't need you coming back to say nothing else. Let us knock out the other ones. Let me give you this too, because we are on paragraph or section 7, and they are just like, and here's another reason, and here's another reason, here's another reason. Because I'm gonna tell you what, since I was like, oh yeah, they didn't. If they're not charging with conspiracy, that whole argument's out the window. And then they just did the part about it has to be as it has to be able to stand alone. Each crime has to be able to stand alone. So yeah, they've already covered it. They're not done, but they have covered it in my eyes. The defendant cites no authority in support of this conclusion. As set forth above, the defendant is not charged in this RICO case with a RICO conspiracy violation. There are no overt acts to allege, and the words overt act do not appear anywhere in count 1. The defendant's demurrer on this ground should be overruled and denied. Count 1 is not required to allege a RICO enterprise because this is not a RICO enterprise case, nor is count 1 required to allege a nexus or relationship between the acts of racketeering activity and a RICO enterprise. The defendant complains that count 1 must be dismissed because the enterprise element of the offense is not sufficiently described. He further complains that there is no suggestion that any other unindicted co-conspirator agreed or conspired to participate in any of the 57 acts of racketeering activity. As set forth in detail above, the defendant is not charged with a RICO enterprise violation. He is charged pursuant to OCGA 16-4-4A with personally engaging in a pattern of racketeering activity over a period of more than 12 years in order to acquire and maintain an interest in and control of real property and personal property. The existence of a RICO enterprise is not an element of OCGA 16-14-4A in the manner in which the defendant is charged, and count 1 is therefore not required to allege an enterprise or a nexus between the acts of racketeering and an enterprise. The defendant relies primarily on Kimbrough v. State, but his reliance is misplaced. The indictment in that case alleged that the defendant, being associated with an enterprise, violated the Georgia RICO Act by participating in the affairs of the enterprise through a pattern of racketeering activity. The existence of a RICO enterprise is an essential element for violations of OCGA 16-14-4B. Here, however, the defendant is charged with violating OCGA 16-14-4A. So, I need Nesto and his attorney more. I feel for the attorney because, like what Shan said, I can understand Shan. What Shan is saying about the defendant is the defense attorney is probably just fouling what Nesto said. I want you to fight this side. I want you to do this. You know, you have to defend me, and this is, you know, whatever. But Nesto, get to be lawyer Sonia to go back and read 16-14-4A because they said they're not talking about B, they're talking about A. It says 16-14-4A can be violated without an enterprise ever existing. Because the existence of an enterprise is not an essential element of a RICO violation under OCGA 16-14-4A, it cannot be an essential element that there be a nexus between the pattern of racketeering activity and an enterprise that is not required. For these reasons, the defendant's demurrer on these grounds should be overruled and denied. Count 1 is sufficiently alleged to survive special demurrer as it alleges facts that identify the basis for the allegations such that the defendant is apprised of what he must be prepared to meet and such that he is protected against double jeopardy. Finally, the defendant complains that count 1 fails to recite facts that identify the basis for the allegations. Defendant's motion at 1, which the state construes as a special demurrer. While a defendant is entitled to an indictment perfect in form, an indictment does not have to contain every detail of the crime to withstand a special demurrer. A special demurrer is without merit where the indictment sufficiently informs a defendant what actions of his are at issue. The purpose of an indictment is to allow the defendant to prepare his defense intelligently and to protect him from double jeopardy. An indictment satisfies due process where it alleges the underlying facts with enough detail to put the defendant on notice of the crimes with which he is charged and against which he must defend. While each count of an indictment must within itself allege the essential elements of the crime charged, when considering a special demurrer, the indictment is read as a whole, and factual details alleged in one count of the indictment can provide the information a defendant complains is missing from another count. Okay, so basically they're like, we don't have to repeat ourselves in every count. Once we have sufficiently stated the necessary details in one count, that's it. We've met our burden on that part. Moreover, while a defendant may desire greater detail about a charge, it is not required that the indictment give every detail of the crime. And additional detail desired may be supplemented by the pretrial discovery he receives and any investigation his counsel conducts. It is not necessary for the state to spell out in the indictment the evidence on which it relies for a conviction, which makes sense because that's why there's different motions for discovery and exhibits. It's not called, I don't think it's called that. But if you've been following the other ones, like even, I know Destiny's is on a smaller scale, but like when, I only have motion for discovery in my head, but there's another one too. Witness list, there's other things. So yeah, that would make sense because they already have their own sections to be done. They're not going to spell everything out in the list of charges in the indictment. I can see that. Boiled down, the Georgia Supreme Court adopted the same fundamental test first set forth nearly 130 years ago by the U.S. Supreme Court to determine whether an indictment is constitutionally sufficient to withstand special demurrer. The test is not whether the indictment could have been made more definite and certain, but whether it contains the elements of the offense intended to be charged and sufficiently apprises the defendant of what he must be prepared to meet, and in any case, any other proceedings are taken against him for a similar offense. Whether the record shows with accuracy to what extent he may plead a former acquittal or conviction. Where the bedrock principles underpinning challenges to an indictment are nearly identical under both Georgia and federal law, the court should view federal authority as instructive, as the former Fifth Circuit sagely counseled. Courts should examine into and determine the validity of attacks upon indictments, especially of this kind, from an enlightened standpoint of common sense. Common sense and right reason, rather than from the narrow standpoint of petty preciosity, that's how I'm gonna say it. Pettifogging, technicality, or hair-splitting fault finding. Although indictments must be specific and precise as to the acts and crimes charged, the law does not compel a ritual of words. They don't need the wordy. They just need you to be specific enough. I'm about to look up the word pettifogging because I need to know. I have a clue because it's in the context of the other words, but I just want to. I've never seen that word before. Pettifogging, giving too much attention to small details that are not important. Okay, learn something new. Yeah, this is when you don't even know 3% of the law goes real bad. Right. Yes, sound checking that. Earnest attorney was listening to Sonya. Yes, I feel, I don't know how attorneys do it because I would be like, I don't want to file this. I'm telling you now, that's not going to stand. Okay, it says here, count 1 is clearly sufficiently pled to survive special demurrer. It sets forth the essential elements of a RICO substantive violation under OCGA 16-14-4A. It sufficiently apprises the defendant of what of his own conduct is at issue and what he must be prepared to meet. And it is sufficiently pled to protect against double jeopardy. It sets forth the specific dates during which the defendant committed a pattern of racketeering activity. It explains in detail that the RICO scheme was designed to defraud unsuspecting individuals, businesses, and government entities with the primary purpose of depriving numerous victims of their property. It identifies with particularity what the defendant stole: U.S. currency, personal vehicles, motorcycles, coach buses, trailers, automotive parts, and other various services and property. It explains that the defendant often scammed his victims by falsely promising to help them engage in new business ventures, to promote their existing business ventures, or to help them build their brand or image. It specifies that the defendant often targeted women using the illusion of romantic or close personal relationships with them to manipulate them and to steal from them. Well, no, it wasn't. It wasn't literally about petty. It was the word is pettifogging, pettifogging. It was specifically a term for that. It wasn't about them being petty, literally. Let me see here. Count 1 explains that the defendant even committed bigamy as part of his RICO scheme, entering into a fraudulent marriage with Shirley Strawberry, a famous radio show host, to use the void marriage and the high-profile celebrity connections he made because of the void marriage in furtherance of other frauds. It details how he recruited co-defendant Erica King to fraudulently assume the identities of multiple attorneys licensed to practice law in Georgia in order to deceive law enforcement and the courts. Count 1 then lists in painstaking detail 57 acts of racketeering activity personally committed by the defendant, alleging with particularity the date of each underlying crime, the name of each person victimized by the defendant, each fraud committed by the defendant, and all of the property stolen by the defendant in multiple states over many years. Count 1 of the indictment leaves no ambiguity surrounding the defendant's 12-year crime spree, which came to an end only when the state arrested and incarcerated him just 7 days after the most recent act of racketeering activity committed by him. Based on these specific factual allegations, all appearing on the face of the indictment, the defendant has sufficient notice to prepare his defense. Notice that may be supplemented, of course, by the pretrial discovery he receives and any investigation his counsel conducts. With these allegations in mind, Count 1 clearly passes the three-part test reiterated in case after case concerning special demurrers in Georgia. 1, it contains the elements of the offense charged. 2, it sufficiently apprises the defendant of what conduct he must be prepared to defend at trial. And 3, it is sufficient to protect against double jeopardy. His demurrer on these grounds should be overruled and denied. For the reasons set forth above, the defendant's general demurrer to Count 1 RICO, Count 1 should be overruled and denied in its entirety. Respectfully submitted this 29th day of July 2024. And it had Fannie Willis and Will Wooten. Okay, so that's the end of that. I think they broke it down pretty well sorry, that's not gonna cut it. All right. I was gonna play a call, but if we do it, I'll just do it at another time because I don't want to drag this live on. And that document was longer to read than I expected. So I will see y'all throughout this weekend. I don't know if it'll be scheduled or I'm popping up, but I will see y'all more throughout this weekend. We have plans for y'all. Me, Don, and Jay have plans for y'all. In fact, one of our appointments today is because of one of our plans that we got to start talking about. Me and 41 Fit have House of the Dragons review / Dragon Party coming up Sunday. 41 Fit, if you're still in here, are we doing 6 p.m. Eastern Standard Time? I don't know for sure. I feel like that might be it, but I'm not sure. Thank you, Kim. I appreciate you. Yes, come on, Dragons. But yeah, hopefully that has us caught up for now. Thank y'all for joining me. Y'all know I love the cases. You know I love the cases, so I love to see y'all over here when we are doing the cases. Thank you so much for being here. I definitely appreciate your presence. Oh, let me say thank you for the cash apps too, and then I gotta pop the trunk for everybody. Hold on, because I definitely heard it coming through. 1 second here. I'm just going to say your first name just in case. So thank you, Cynthia, for the cash out. I appreciate you so much. And then I want to say, because I was offline for the other ones, thank you, Pacino Rules. I say Pacino. I say Pacino Rules. I say Pacino. Thank you, Pacino Rules. I definitely appreciate you. Bam, bam, Bama girl. You already know. I appreciate you so much. Let me see here. Was that DG? I don't know if that was DG or not. I feel like DG was in here somewhere though. So thank you, DG. I appreciate you. Veronica Monroe, thank you so much. I'm also going to say thank you to April. And then I think that's where it stops, where I didn't get to say them out loud. So I thank y'all very much. That definitely is helping me because that went to the document fund immediately. So I definitely appreciate the cash apps. And thank you for the super chat as well. Thank you, Dwayne is Pierre. Thank you so much. Let me find the trunk so we can pop that trunk. And I will see y'all again this weekend. I can't wait. All right, so y'all YouTube gonna be notifying y'all all the time, but just still keep the notifications on just in case, and I'll talk to y'all later.
All right, we going. What a money reside, what a money reside, what a money reside, what a money reside.
Okay, bye.
I've been taking my time, taking all of your time.